Sitting beside me is Mr. Lee Siegel from Tampa, attorney, came all the way up here just for you. Pretty, isn't he?
Never been accused of that before.
Never been accused of that before. All right. Anyway, what we're going to do is go through the report that I prepared, largely with his input, and discuss this Dodd-Frank thing and make the best sense out of it that we can, and educate you to the point to where at least you got something to work with when you get out here selling or buying with owner financing. Now, this is going to come with a huge disclaimer and disclosure that you cannot assume that you're getting legal advice here, even though there's an attorney up here. He ain't sending you a bill. Well, we could fix that, though.
We can.
What we're about to tell you is the best that we can determine from what we know, and Lee and every other attorney that I've ever talked to will tell you there is so much in this law, this 858-page law, that is up for interpretation. As usual, they did a great job of writing the law so that it's clearly understood by anybody who reads it. That was a joke, incidentally. I have prepared the questions that are in this report, which is being handed out to you, based on my knowledge of the real estate industry as it applies to us. There's a whole heap of stuff in Dodd-Frank that doesn't apply to us, but that's not my problem. My problem is to take care of us the best that I can. And as we go through this, you're going to have questions, and we're not going to answer them until we're through, or we'll never get through. So this is how this is going to work. We're going to discuss the points. He and I are going to go back and forth. We're actually probably going to disagree on some items. That won't be a shock, would it? No? Okay. And that's okay, because I can tell you right now, you put 5 attorneys against the wall and ask them the same question, and you're going to get disagreements galore.
You'll get 6 different answers.
6 different answers. Okay. And you know why they're all lying, don't you? Because their lips are moving?
Lips
I ain't going to go there. Promise, Lee, I wouldn't do any attorney jokes.
I'll do the attorney jokes.
You'll do the attorney jokes?
Yeah.
All right, I might learn some new ones.
You might.
All right. This report that you have I created it based on actual conversations with 4 different attorneys, input from him, of which we hired him to do, and reading at least 7 or 8 other reports generated by other attorneys and non-attorneys, and all together is what you see here. Now, even in those reports, there were some conflicting opinions, but by and large, across the board, there was mutual agreements for the most part. There's just a few points and the reason there's a few points that are conflicting is because it's not clear in the law, to be honest with you. Now, the downside here is that, great, we have the law, but we have no case histories. We have no track record to go on. We have no evidence from previous trials that produce the evidence, which is pretty much relevant in all lawsuits. We got something to go on. Here it's all brand new. And my goal is that you aren't the case studies for future use. But never forget, when all else fails, you can serve as a warning to others, right? Let's start this off by reading something one of you just gave me, written by some, I guess, lawyer, and a lawyer in Wisconsin, and frankly, I think I wrote it. It says, in my opinion, the SAFE Act and Dodd-Frank included fixes to largely imaginary problems, i.e. consumers getting seller financing through fraudulent means or on unfair terms. I can offer no explanation for the restrictions on seller financing except that the legislation to fix the financial turmoil caused by large financial institutions was drafted by the lobbies for these same large financial institutions. Asking Dodd and Frank to guard the large bank henhouse probably makes less sense than asking Bernie Madoff to serve this function. At least this story would make enough sense to fool the public. There is no factual basis of which I am aware upon which to conclude that seller financing had anything to do with the financial meltdown. I absolutely couldn't agree with him more. The truth is, seller financing is about that much of the total financing going on in this country anyway. But hey, here we are. Do we get to make the laws? No, but we get to fire politicians, don't we? Yeah. All right. So let's get going. Let's start with this Dodd-Frank report on seller financing. Oh, I forgot. You're going to tell them about what you do in your practice.
Sure.
Cut you
well,
off.
As Ron said, I have a practice in Tampa Bay area. My office is
Speak up.
actually in Clearwater. I have a partner, Jill Shue. She practices with me. We opened up the firm back in 2007, coming right out of law school. And going through, I've had many real estate transactions, both on the buyer and the seller side. I do a lot of foreclosure defense work, keeping the big banks who are subject to truth in lending and all the consumer regulations in their place. And I do a lot of commercial transactions, contracts, securities, things like that. So pretty varied civil litigation, but I do have a big focus on the real estate market.
So you are one of those guys that goes after banks.
Oh yeah.
You're one of those guys banks fear, huh?
Well, my last 10 foreclosure trials, where it was admitted that there was a mortgage and there was a note, and that my clients haven't paid in 4 to 5 years. Out of the last 10, who can guess how many of those the bank won a foreclosure on? 3. And all those 3 could have been appealed. Fortunately, my clients don't have the money to do an appeal or post a bond to stop the sale, but in the end they end up getting a waiver of deficiency and walking away from the house not owing any money. But the other 7 are still in their homes over 5 years and awaiting to be served a new lawsuit from probably a new bank, because I was able to prove that the bank that brought the suit didn't have standing to bring the suit.
Okay, so the moral of this story is, if you get into a foreclosure situation, you ought to be fully aware of your rights and approach someone who understands what they can and cannot do, and not some attorney who's never sued a bank and has no idea what they're talking about. As always.
You don't want a criminal defense attorney doing your foreclosure defense. You want a real estate attorney who understands the mortgages, the notes, and all the issues that go around with it, because attorneys are licensed to practice law, but that doesn't mean they're competent to practice every area of the law.
I never met an attorney that was competent to practice every area. In fact, let me cut that sentence off in the middle. No, I'm not going to do that. Competent to practice law in every area. There is no such attorney, and most of them will tell you that. But, some of them try to do things they really shouldn't be doing.
Exactly. That's the big problem, is you have to make sure that the attorney you hire knows what he's doing for what you want him to do. He may be a great criminal defense attorney, but he may not know thing one about writing a contract. And so that's not the guy you want writing your contracts.
All right. Turn to the first page on page 2 and see. Look at the disclaimer. It's very simple. I'm not an attorney. We're not giving you legal advice. In fact, you can't even trust the advice we're giving you. In fact, I wouldn't even believe it if I were you. Here it is in writing. But when you get back into the real world, you've got to verify your own facts. And honestly, these facts are going to change, because as time goes on and we actually get case study concerning this Dodd-Frank thing, we are going to have some changes. There's a lot of things in this law that I cannot imagine what earthly good they do. And I bet you over time they're probably going to be waived. So let's just get to them and get through them. And remember, when we're done now, you get to ask questions. So I'd be writing them down as I go, and I'm probably going to have to limit those. We can't be here all day doing this one thing. Let's start with the first one. The Dodd-Frank takes effect on January 10th, 2014, and changes the rules for seller financing for those not qualifying as exempt. You see, that's incorrect already, because it changes the rules even for those that are qualified for exempt. The most relevant changes are, and this report discusses each of these. 1, it requires every lender to consider the borrower's ability to repay. And from what I understand, even if you are exempt. Correct?
Yes, if you are lending money, you have a duty to make sure that the person you're lending money to has an ability to repay, and there's 8 specific factors, which we'll get into later.
We'll come back to that
You have to examine when you're doing that.
All right? Which is number 2. It requires the lenders to consider 8 factors. We'll come back to it. doesn't require you to prove those 8 factors, but to consider those 8. The onus is probably going to be on you if you ever got into any litigation. The lender must write a qualified loan. Well, actually there are non-qualified loans, but you want to write them. The rules are so stringent on those. We'll come back to that, what a qualified loan is. Requires lenders to wait at least 120 days of delinquency before foreclosing. Did you catch that?
Yeah, it's actually 120 days, and you have to give the borrower a chance to do some loss mitigation,
Yeah.
or try to cure the default, give them a mortgage modification that's going to be able to let the borrower stay in the house.
Come back to it. Dodd-Frank combined with SAFE Act in various states will require all owner finance transactions, except the exceptions, to be originated by a residential mortgage loan originator. That's, well, again, I'll come back to that. Prohibits builders from selling with owner financing. Frankly, I couldn't be more clear on that one.
Mm-hmm.
That's not one up for debate. Sadly, if you build houses for some weird reason, you can't sell them with owner financing. Now, I have no idea what possible value that law is, except to limit my ability as a builder to rotate houses and provide more housing. But there it is. Eliminates balloons and negative amortization loans and requires fixed rates for 5 years with no prepayment penalties. Sellers who sell with owner financing more than 3 times a year will become mortgage originators and must comply with Dodd-Frank. And no forced arbitration clause is allowed in the buyer's note. So let's go through these and other questions. All right. First one is, what information am I required to get from buyer to prove their capability to repay? And this is in Subtitle B, Section 1411. And it's there for you guys to go read it for yourself. In fact, you ought to go pull up the Dodd-Frank law and read every word of it. Twice.
If you have nothing to do for a couple days.
And you ought to be doing this in bed at night while trying to get to sleep. At a minimum, creditors generally must consider 8 underwriting factors, and yet there's nothing in there that says I must prove in a file that all of these factors have been considered and have evidence of it.
Correct.
Am I correct?
It is a recommended guideline, which means until somebody actually sues a creditor for not considering number 6, we won't know if that's a required or a recommended guideline.
Number 1, current or reasonably expected income or assets. Now, shouldn't we do that anyway? All right, I just went through that yesterday or today or whenever it was. And I will tell you that I told you that the debt ratio that is mentioned, and yet I see no evidence that it is required, is 43% debt ratio, total debt now, which includes the house payment. Do you see anything that was required?
No. I've seen numbers, I've seen the number 38 a lot, and I've seen the number 43, and 43 seems to be the maximum that is allowed.
But yet, it doesn't say if you exceed 43%, you're violating the law.
No, it doesn't.
Okay.
It's a guideline.
The guideline. Okay. Current employment status. In other words, if they're unemployed and they have no income, probably shouldn't sell to them. So in other words, should you prove that they are employed? A check stub would do the job. Mm-hmm. The monthly payment on the covered transaction. In other words, can they afford the payment? And you should probably use a 28% of gross revenue on that one. Does the PITI exceed 28% of their gross family revenue? Remember now, family revenue is husband and wife, all income. Now, I think you've got a little latitude here. I can tell you right now, FHA will absolutely have to have ironclad proof of that income. I think we can reasonably assume that the income on if they say to us, I make $1,000 a week at the flea market, I think we can reasonably assume that is correct. Would you agree?
You can assume it. It's more recommended that you ask them to see, let's say, a month's worth of bank statements to show the deposits from the flea market, because while they may not reflect those on their tax return, since they're probably running a cash business, you want to get some kind of independent third-party verification from them,
Yeah.
from some independent third
I
party.
didn't see any law that says that we can't finance them if they're screwing the IRS, did you?
No.
Okay. The monthly payments for mortgage-related obligations, which I guess means other mortgages?
Association dues,
Oh, yeah, got it.
things like that.
Association dues. In other words, you have to add that, remember, to the payment if there is association dues, all right? The monthly debt-to-income ratio, or residential, or residual income, which we just discussed actually, and credit history. Now, credit history, okay, so what? I got their credit report. Well, what about it? All the people we finance, the FHA won't. So I don't know what to tell you about the credit report. I'd say I'd want it in my file. And I'd say if it's really, really, really atrocious and you still want to accept them, you probably ought to have some justification in there why you should. I think it's actually a good idea if you put a one-page report in each file that how you came to the conclusions you came to accept them. Don't you think so?
Yeah, what factors you considered,
Yeah.
what documents you reviewed, and that way, if anybody comes asking any questions, you have the one page to hand them and say, here's the answer.
And then it says creditors must generally use reasonable, reliably third-party records to verify the information they use to evaluate the factors. What's reasonably reliable? Not defined. What third-party records? Not defined. So common sense takes over. So here's what I want you to ask yourself. If I ever get attacked, am I going to be proud to take this file into court and defend myself? And that's the best you can do, guys. That is the best you can do. And by the way, I'd say if you have this file, there's little chance you're ever going to get to court. Wouldn't you agree?
Yes.
Yes? Okay. What is a qualified loan? Well, here you go. Here's the ugly part. It cannot have a negative amortization. No negative AMs. And it cannot have a balloon payment, which I'm telling you, I'll bet you the biggest lobster dinner in Jacksonville that's going to change. Because I know for sure that NAR, National Association of Realtors, are petitioning to get that changed. Even they know how important that is to us in the world of seller financing. And if they don't get it positioned to be changed, I'll bet you there's some other groups that will, because that is totally unfair. That is totally unfair to the seller. And Mr. Dodd, Mr. Frank, I hope you're watching this. You screwed up on that one, Bubba. That is totally unfair. Must have and must be for 30 years or less. In other words, I mean, what does that mean? Oh, right, we can't write a mortgage for more than 30 years.
Right.
Okay. That ain't a problem.
It's ironic because a lot of the mortgage modifications I'm seeing now offered to my clients have a 40-year amortization schedule.
But I bet they won't after January the 10th, will they?
Well, no, because this is a modification. It's not an original purchase.
Oh, so they can modify any way they want.
Oh, yeah.
Oh, so you're telling me.
The bank's already in the game.
Yeah.
So they've already given the bad loan. So now they're modifying it so they're not subject to Dodd-Frank.
So I wonder if I give a bad loan, can I modify it? No, we ain't going there. All right. Yeah, move your mic up.
Is that better?
Cannot have prepayment penalties in excess of a schedule set out in the regs. I don't know what the schedule is. The truth is, just don't have prepayment penalties and don't worry about it. You rarely would do that anyway on a seller carryback note.
The prepayment, I think, is 2% in the first 2 years and 1% in 3 years, and you can't have more than 3 years as a prepayment penalty. 3 years is the max.
All right. Can be a variable rate, but the underwriting must be based on the highest interest rate it can be during the first 5 years. I'm going to tell you you're probably a lot safer to not have a variable rate during the first 5 years. And we are going to discuss how to handle balloons and how to adjust, because we can't have balloons here. And the creditor must verify income and assets and debts through third party. We covered that. The creditor need not verify employment status per se, monthly payment per se, or or simultaneous loans except as they fit into the debt to income ratio. Not sure why they wouldn't. If they have other obligations, they'd have to fit in the debt to income ratio, or would they? Maybe that means if they have a rental property, I don't have to consider that into their personal debt to income ratio. Do you know what that means?
If the rent is covering the mortgage, then yes, you could not include that in the debt to income because the income offsets the debt.
All right. The creditor need not verify credit history, but as a practical matter, we'll do so. We're going to verify credit history anyway, aren't we? Yes? Yes. All right. Okay, the 120-day rule. What is that, Lee?
120-day rule says that when your borrower starts becoming late, in the old days, as the banks would call them, the good old days, you send them a letter that says you have 30 days to cure this default. If you don't cure the default, we will accelerate your loan, demand the entire balance due, and start foreclosure proceedings. That's gone. You now have to wait a minimum of 120 days, and during those 120 days, you have to make a good faith effort, another term that's not defined, to contact the borrower and try to work out something with them in the form of loss mitigation, modification, get involved in the short sale negotiation with them, or have them do a deed in lieu of foreclosure.
Well, if I have a problem with them, my first goal is to get a deed in lieu of foreclosure anyway. So what would you suggest? First, we should issue them, now it's not a 30-day notice, it's a 120-day notice.
Yes.
But that notice should be issued immediately.
Oh yeah,
upon default.
Upon default.
And then I think we probably should send a letter offering a deed in lieu of foreclosure. Wouldn't you agree?
Right away, because that saves both parties a lot of time and headache. If the borrower is a reasonable person, they've come to the realization they were able to afford it, circumstances have changed, they're not able to afford it, easiest way out, deed the property back to your lender and walk away. You don't owe them any money, they get the house back.
That's the way you want to get out anyway, guys. Long before Dodd-Frank. Your whole goal is to go to them and peacefully say, look, I don't want to come after you. I don't want to destroy your credit. Give me the house back. Get out. Come back and see me when life turns around again, and I'll give you some credit for the down payment you gave me toward another house. That's the way we handle it. And that eliminates most of your problems. But on the other hand, you need to go into this assuming that you're going to have a totally uncooperative buyer. So therefore, you must know your rights and know your responsibilities. So I'd say have an attorney send a letter for the deed in lieu.
Oh yeah. Well, people, in my experience, people take a letter from an attorney a lot more seriously than a letter from the guy that loaned them the money or the girl that loaned the money. Once they know an attorney's involved, they know things are going to get serious very quickly. They tend to be more proactive and try to resolve the situation, as opposed to, oh, I got a letter, I can ignore it. When he hires an attorney, then I'll pay attention.
Right. Now, the borrowers are soon going to learn, well, you're going to tell them they got 120 days before you can file. I would imagine we're going to have to deal with the fact that they know they can live there for 4 months for free. So you need to deal with the fact that at the very least, you might have to write them a check to get the deed back. You're going to write a check anyway, aren't you? One way or another, you're going to write a check to get the deed back, aren't you? Okay, a lot easier to do it peacefully. Now, I'm not so sure I'd want to offer that right up front. I'd want to see if we can't solve it peacefully, because you do have their credit in your hands, guys. Once you file that foreclosure, their credit is just dropped 80 to 100 points. Now, can I point that out to them in a letter, or is that violating the code?
Well, Truth in Lending and the Fair Debt Collection Practices Act both have a lot of restrictions on what you can and cannot say, what you can and cannot threaten. You can, in general, use generalities like, if you don't do this, it may have an adverse effect on your credit. Therefore, have you really said anything? Because it also may not have an adverse effect on your credit. So it all depends on how the person reading the letter reads it. You say, if you fail to comply with what I'm asking you for, it may adversely affect your credit. You've basically said nothing, although it sounds like you've said a lot.
Yeah. You know, I really don't want to create any harm in your life. I know you got issues of your own, but I'm sure you're aware that once I file foreclosure, it will go in your credit report and reduce your score tremendously. I don't want that to happen, and I know you don't either. That's different than saying, I'm going to wipe out your credit, moron, if you don't give me the house back.
Don't say that.
Yeah, don't say that. All right. Okay. Now, right now, I'd say if I offer them a deed in lieu and they don't respond, I'm wondering if I'm obligated to do anything else except wait out the 120 days, except maybe hit them another time or two with the same offer.
No, you have the duty to interact with them, but as to how many times or what you have to offer them, there's not even a guideline. You have to offer them some kind of loss mitigation. A deed in lieu is a form of loss mitigation. The funny part is that the big banks, before they'll even consider a deed in lieu, force the borrower to list the house for a short sale for 90 days. And they will not consider a deed in lieu unless the house is listed for 90 days, no offers are accepted, then you can apply for a deed in lieu. Whereas you guys will take the deed in lieu right away, which is, I think, a much smarter solution for both sides.
Okay, good. All right, now what makes me a mortgage originator? I can tell you, you don't want to be one.
Not if you're not licensed.
You don't want to be one even if you are licensed. How do I become an exception? All right, the rules are, a loan originator is a person who, in any expectation of direct or indirect compensation or monetary gain for performing this following activities. Look, it's this simple. If you have anything to do with the process of putting borrower and lender together for a fee, you need a mortgage originator's license. However, is that what we're doing? Now, we're selling our asset and taking back a mortgage or a deed of trust or a land contract. So unless we violate some provisions of the law that says we are a mortgage originator's license, like collect fees for doing stuff for other people, then in my opinion, that's something we probably don't need to give too much concern to. Agree? Huh?
No, I don't agree.
All right. Well, why?
Because if you look at number 1, performs any of the following activities, and they're commas, so they're all assumed to be ors, not ands, because there's a big difference between or and. So number 1 says takes an application, and then we have to skip to takes an application, obtains or makes an extension of credit. Are you giving them credit when you're making them a loan?
All right. I'm the opposing counsel.
Go ahead.
We're arguing this in court. But Mr. Siegel, the first line says that I have to be a person who expects compensation, indirect or monetary gain, to perform this function. And I would believe that the law's intent was that if I'm doing that for compensation for the services of others. Your Honor?
Well, Your Honor, I would argue that another person is the person getting the credit. And so the person who's giving the credit is subject to the loan originator if they're making an extension of credit to another person. The other person
Your Honor,
being
since time
the
began,
borrower.
mortgage brokers and mortgage originators have been providing services to collect fees for the others. I see nothing in the law that specifically states that I can't sell a house with owner financing without qualifying as a mortgage originator. So, Your Honor, this is up to the interpretation, but I believe the intent was that if I'm performing services for other. Now it's up to the judge, and it depends on whether he got laid that morning.
Or just what he had for breakfast.
That's correct. All right. Okay. All right. Let's move on to balloons. Balloons are not permitted. You know what, though? While we're on that subject, why don't we just do it now? In here, I believe it says, in fact, I know it says at the end, that I think, and many others I've talked to think, it's probably not a bad idea for you to hire a loan originator to handle the paperwork when you're selling with owner financing anyway, because A, it takes liability off of you, or some liability off of you. B, that's their job, and they're not very expensive. I mean, for a few $100s, you can hire a licensed loan originator to be in the middle And I mean, I can tell you for sure, that puts a lot of weight in your favor that you intended to comply with the law, even if the other side wants to pick it apart, which they probably will. Again, he who has the biggest preponderance of evidence, and an attorney who can state that evidence and make the argument, is usually going to win. Now, you're not going to argue me well on that one, are you?
No.
Okay,
if you
good.
have a licensed mortgage originator, you're in a much better position than someone who doesn't.
All right. Write down your questions. All right, balloons are not permitted, but there are provisions allowing interest rates to rise each year. Must it be fixed for 5 years before increase was my question. How much can it increase? Okay, the answers were those restrictions apply if you're trying to fit under the exclusion to the originator rule as a seller financer. Once you are doing more than 3 loans per year per person or entity, all the provisions of Dodd-Frank apply. In other words, what Lee said, because that is his response, is that if you put a balloon in there, whether you think you're exempt or not, we're getting to exempt, you are violating Dodd-Frank as we read it. Is that correct?
Yes, Dodd-Frank says lender shall not make loans with balloons. Subject to the exceptions in Dodd-Frank.
Okay. So I'm having trouble with this one, to be honest with you. I cannot get a definitive answer from anyone on this one, likely because there is none. But I am absolutely going to keep searching until I find one, and that is, if I'm exempt, how can I be held accountable to the laws that I'm exempt from? It doesn't make any sense to me. And we're going to be exempt here in a minute, because the truth is, guys, your whole goal here is to be exempt from Dodd-Frank. Because if you're not exempt from them, it puts a lot of pressure on you to comply that we can easily exempt ourselves from. But unfortunately, the way it reads now, we can't be fully exempt, because there's a few things we got to do even if we're exempt. But let me finish that one first. It says down there at the bottom, the qualifying exclusions, restrictions on adjustable rates is that they can only adjust after 5 years and must have the margin tied to an index such as LIBOR. Additionally, they must have reasonable annual and over the life of the loan limits, and it appears that number is a maximum of 2% annual and 6% lifetime increase. The people that I've talked to, all right, here's my recommendations, which mean nothing to you. I'm selling with owner financing. I'm going to set that rate as high as I can on the front end to encourage my buyers to refinance as soon as possible anyway. And can't put a balloon in it. I'm absolutely going to put a 2% increase in that interest rate in year 6, and a 2% in year 7, and a 2% in year 8. Thus almost forcing them to refinance or making a very high payment, since we can't put a balloon in it. If I set the interest rate high from the beginning, then I'm giving them plenty of motivation to refi. However, there's a limit to how high we can set the interest rate.
Yes, under HOPA,
Okay.
you become a non-qualified loan if you're, I believe the number is 6.5% over the annual percentage rate. That's the market rate.
6.5 on a first and 8.5 on a second.
Correct.
Are all your sales to your buyers going to be seconds? They're going to be wraps. There's going to be an underlying loan underneath it, so they're going to be wraps. Even if you buy it free and clear from the seller and owe them, when you sell it, it's still going to be a wrap. Everybody understand that? So it's a second. So for all intents and purposes, your loan rate is maximum 8.5%, the way we read this. And then write your questions down. And in year 6, it goes to 10.5%, to 12.5%, to 14.5%, according to the law, according to the way we read it. All right? So how do I become exempt? Isn't that the big question? Don't originate more than 3 seller finance deals per year in any entity you control. That's one. Come back to that. Commercial deals are exempt, period, across the board, no question. Agreed?
Yes.
And loans to non-owner occupied buyers are exempt. That's what I'm told. I think you disagree with that.
I do.
Okay. They are commercial loans, as far as I'm concerned, and most other people is concerned. And there's evidence that this law is written for owner-occupied houses. But honestly, one of us is wrong.
Well, there's a conflict in the definition section of the Act, in that some definitions refer to the primary residence of the borrower, others refer to a mortgage secured by a dwelling. And a dwelling is just a house. Doesn't matter if anybody lives there or not. 1 to 4 family condo, that's what a mortgage is. So if you're a lender and you're making a mortgage loan, you're doing it on a dwelling, not necessarily a primary owner-occupied dwelling.
Yeah, and then I'm going to make the case that it is a commercial type deal provided to an investor. And honestly, I'm going to tell you from all the opinions that I've collected, they agree with me, not him.
Everybody's entitled to an opinion. They're like noses. Everybody has one.
They are. All right. Okay. Now, if buyer and seller are both an entity, excluded.
Absolutely.
So there's a case to be made there. Especially if I'm dealing with investors, that's easy. I'm an entity, they're an entity. So no problem with that. But there's a case to be made there to maybe sometimes create an entity, if need be, just to make it apply. But honestly, I'm so convinced that it doesn't apply to non-owner occupied property that I ain't gonna worry about it. Maybe I'll be your test case, huh?
Or you could just be safe and have entities on both sides.
But
Then it is a commercial transaction.
That's gonna be easy, harder than it sounds, Lee, when I'm dealing with owner occupants. Hard enough to get them to understand what I'm doing. But, well, actually, let's come back to that. All right, here's some good news. I read it in there, and others read it in there, that I'm dealing with an owner-occupant, and they're selling their primary residence, that they are exempt. But even if they aren't, I'm the buyer. I am the only one that even can create the issue. The sellers are the ones getting held liable for violating Dodd-Frank, not the buyers. So if the buyer doesn't complain, there is no issue. I'm the buyer. Got it? But I do have to resell. So in other words, when I buy on a balloon, if I buy with a balloon, and I don't have any problem buying with a balloon, but the only problem is how am I going to exit? Because I can't put a balloon in my exit. So the only thing I can do is what we just discussed. But it doesn't mean I can't lease option with my exit. Can I still buy with a balloon and lease option and give that lease option buyer a term much shorter than my balloon? Yes. I have no problem buying with a balloon. And again, I'm the buyer. And if I don't complain, there is no issue to even be concerned about. However, there might be an issue if I agree to buy with a balloon and then assign that contract, and my new buyer creates an issue down the road. Agreed?
Yes.
So you're not going to be able to do that. If you buy with owner financing and you give the seller a balloon, and you're going to have a little trouble on the back end because you can't put a balloon in it for the buyer. So that's even right now that's a bigger problem for Texas than any place else, because you can't lease option it to the end of that term. So the only way you're going to be able to buy from the sellers is without a balloon, unless you intend to cash out of it. Because I wouldn't want you to assign that contract with a balloon to a buyer, especially when you know that buyer knows nothing about Dodd-Frank. So you're putting that buyer in a position to where you're setting them up for a legal issue later on down the line they didn't even know they had a problem with, which of course could bring you right back into the lawsuit. Agreed?
Yes.
Yeah, you set them up because you had knowledge. You're the investor. You're the one that should have known that passing that illegal contract on to them would put them in harm's way. All right, let's move on down to how do I become exempt? Well, let's go back to 3 deals. Your next question, incidentally, is if I become an exemption, well, the next one is, if I become an exemption, does the law, any of the law apply? And the answer is yes. Here's the part of the law that applies. Number 1, still no balloons. fixed rate for 5 years, and you must do some kind of qualifying that they have the ability to pay for the debt, even if you're exempt. The only part that bothers me about that was the balloon. That's the other part I do anyway. So what must I do or not do to buy and sell with owner financing? Well, buyers are the ones receiving the protection, and therefore none of this applies. Sellers who sell with owner financing more than 3 times per year will become mortgage originators and must comply with the requirements of Dodd-Frank. So if your entity sells more than 3 per year, you must comply with all the rules. Now look at the next question. Can I do 3 deals each in different entities if I control all? And of course, you're going to get conflicting opinions on this one. What's yours?
Well, I think that's part of my answer. I recognize in there. That's a very complex question. Corporations and control factors have many different interpretations by many different governmental entities. Now, the Dodd-Frank Act sets up the Consumer Financial Protection Bureau, and they're going to be the ones interpreting the violations and bringing cases. So if they determine a control person to be different than what, say, the SEC determines to be a control person, then you're going to get a different result. A control person is a term that can be defined by 4 lawyers in 10 different ways, because there's so many factors that go into what makes somebody a control person. So if your name is on the state website as the president, I'd say you're a control person. But what if your name isn't on the state website, you're the 100% shareholder, the president's your brother, and you just tell him what to do? Are you then a control person? Some would say yes, some would say no. If you're not an officer and director, can you be a control person? The SEC says absolutely. If you own more than 10% of the stock, you're considered an insider and you have some influence. If you ask the Consumer Financial Protection Bureau, I don't know what they're going to say because nobody's ever asked them.
All right. Now here's my interpretation and the feedback I've gotten from a couple of extremely good lawyers who've been in this industry for a long time. The answer is very simple. There is nothing in Dodd-Frank that defines whether they can be controlled or not controlled entities. Therefore, actually, what you just said is true. It's entirely up to the person or interpretation of whoever may be challenging you. But I have not found anybody else that has a problem with you doing deals in different entities, even if you control the entities. Now, if you want to be safe, then you do 3 deals in each entity and you don't control them, which is not that difficult to not do. By the way, the entity that your IRA owns, you don't own. That is definitely not you. And you better not be controlling it or you're self-dealing with your IRA anyway. The entity your wife's IRA owns, same thing. There's 3 deals each right there for you. The entity that your own entity and your wife's entity, whether your wife and you are the same, depends on who's challenging you. Now, do not confuse this with an IRS rule. You know, if I have 5 entities and I control all of them from a tax point of view, as far as the IRS is concerned, that's all a control issue, and it's kind of like one. But this ain't the IRS. These aren't IRS rules we're dealing with. They're Dodd-Frank rules. And you're going to find a lot of conflict in there. So in my opinion, well, first of all, most of you aren't going to do enough deals with seller financing to where this even matters to you. But if you just split those entities, I think you're going to be fine. And if I'm wrong, we'll send you cigarettes in jail.
And in Pinellas County, there's no more cheese in the bologna sandwiches, just so you're aware.
No more cheese in the bologna sandwiches.
Nope.
All right. Well, the good news is here, we're not talking criminal anyway.
No.
We're talking civil. We're talking money.
Yeah.
So nobody's going to jail unless you really do something incredibly stupid. All right. In fact, the next question is, what if the penalty? What is the penalty if I don't comply with Dodd-Frank and I'm not exempt? And I'll let you tell them.
Well, the consumer or the borrower can sue you and get back everything they've paid in financing charges over the last 3 years. What's worse is if you go to foreclose on them, they don't have a statute of limitations on asserting their defenses under Dodd-Frank and they could use it as a recoupment or a set-off against you in the foreclosure action. So if the loan's 10 years old and they show a Dodd-Frank violation, they could still recoup the 3 years worth of finance charges and everything else they paid to you, even though that's 10 years ago. Plus attorney's fees and costs.
If you lose.
Yes,
Don't forget, just because you get sued don't mean you lose.
unless you're sued by me.
I can't tell you how many attorneys have told me that.
You didn't have me defending you.
No, I can't tell you how many have told me that, and I didn't lose.
Because you didn't have me defending you.
Because you didn't have me prosecuting.
Exactly.
Prosecuting.
That's what I meant.
Yeah, okay, I got it. All right. All right, next. We sometimes do 10-year lease options when homes are over-leveraged. Will this be considered as owner financing? And if so, and it's really this simple. Now, from an IRS point of view, any lease over 3 years would be considered a sale. Mm-hmm. So let's start right there. Who cares? We buy houses from owner occupants. What if it is considered a sale? What's the difference? It's tax-free anyway. It was their home. And if it's not tax-free, it's an installment sale. Pay taxes over the years, and that's on the fluke rare thing that the IRS would come in and audit them and say it's a sale. So, we sometimes worry about the wrong stuff. Besides, if I'm going to go in and the only time I'm going to get a 10-year lease is on an over-leveraged house, isn't it? It's the only time this even matters. On an over-leveraged house, if I don't get the 10-year lease, I'm not doing the deal. I don't care if the IRS considers it a sale or not. But what if they do consider it a sale? My house is over-leveraged. I'm not going to get taxed unless there's a gain. How am I going to have a gain when I actually got to sell the place cheaper than what I paid for it in the ultimate end? So don't worry, don't go down that wrong trail for no reason. This is a different rule. What this says is, if it looks like a sale, it might be considered a sale, and if it's considered a sale, it has to comply with Dodd-Frank or be exempt. If you have a lease option that does give the buyer credit for debt reduction, it would be considered a sale. The buyer cannot acquire equity as part of the lease option, or it would be considered a sale. Correct?
Yes.
All right. Now, what that means is, if I'm sandwich leasing it and I'm installing a tenant buyer, it's irrelevant because I'm not giving them credit for debt reduction anyway. Am I? Hello? All right. However, if I'm doing a 10-year lease option from an over-leveraged client and they do get the benefit of the debt reduction and I assign that, could that be considered a sale?
Yes.
Yes?
Mm-hmm.
But it's my opinion that sale from that residence is not going to be a Dodd-Frank issue anyway, even if it becomes an issue later. But as it says in here, there should be a disclosure statement at every closing involving any kind of owner financing or perceived owner financing that we believe this transaction does not come under, or we are exempt from Dodd-Frank, and it does not apply to this case. And that should be prepared by your attorney.
And that is one of the very important things to take note of. A disclaimer saying that and initialed off by the borrower is something that you can later bring up in court, because you say, you can't come and sue me now under Dodd-Frank when you acknowledged that this transaction was exempt for Dodd-Frank. Even if it wasn't exempt from Dodd-Frank, it was explained to you, you had an understanding of it, and you signed off on it, and it wasn't in 8-point font at the bottom of the contract, it was in 14-point font at the front of the contract. So it wasn't something that was hidden from you, it wasn't something that we tried to trick you into. We told you up front. Now you're coming back 10 years later and saying you violated Dodd-Frank. Here's a disclaimer you signed. And so that may not win the day, but it's going to take you a long way towards winning the day.
All right. Well, in reality, most all litigation comes down to the true intent. So the more you go to prove the true intent, the better the odds are with you. How do we prove intent? We get it in writing. Remember the CYA letter? Yeah? We get it in writing. We get every point initialed. We get it done in front of an attorney so that there can be no argument, at least, that at the time you did it, the other party understood the deal. And if you don't do that, and you get to court, your word against theirs, and what mood the judge is in. The judge is going to have a hard time overruling physical evidence in front of him that the true intent was clearly disclosed. Now, that doesn't mean you're necessarily innocent, because you cannot override the law even with good intent. Here's something. By the way, are you going to read a lot of gloom and doom concerning Dodd-Frank? Oh, yeah, everybody's got their opinion. Now, let me ask you something. Could I get more people to come to my blog, subscribe to my email, and buy my magazines if I preach gloom and doom than if than if I'm positive? Oh, people want to come and read the horrible stuff. So they have something to talk about, don't they? So you're going to see a lot of people out there, especially online right now. I mean, some of them are just printing totally false stuff to build their readership. And I just got a report from one of them. I don't even know who this is, nor do I care. But this is just the kind of stuff we're talking about. Historically, seller carryback financing was an option to help get buyers with damaged credit back into a home. However, the day of seller financing will soon come to an end. Is that what you want all your competitors to read? Yeah. So if they want it to come to an end, their choice. Not going to come to an end around my house. It's going to change a little bit. But if I'd have listened to that crap over the years, everything we do would have come to an end. I remember a time they were going to outlaw wholesaling. At least that's what the gloom and doomers said. And then they were going to outlaw subject twos. And then they were going to outlaw lease options. Well, they did in Texas. In fact, you know how the Texas law came about? Because I talked to somebody who really on the inside of that. Texas, they did the law in Texas to outlaw collecting non-refundable option deposits, and the reason it went through is because nobody was disputing it. Nobody was disputing it. They passed a law, had no idea what they were doing. They only had one side of it, passed it anyway, and frankly, from what I'm told, later regretted doing it, but nobody's reversed it yet. You're going to see a lot of that crap here. Now, we're not even going to get into Obamacare. Huh? We're not even going to go there.
That's 10 days before Dodd-Frank. That's January 1st.
Now let me read you the opinion of an attorney, another attorney, a very skilled attorney, I might add. He's been around forever and is a real estate investor on this number of deals per year. And you can do your own conclusions. You can do 1 deal per year as a natural person or trust, 3 deals per year in an entity without being licensed under Dodd-Frank. Do you know that? You can do 1 deal a year as a natural person and be exempt. That's your sellers. That's all your sellers. If your state has no exemption under the SAFE Act, which is another issue, is your state rules. Do you think the state rules are going to be much different than the federal rules?
No, as a matter of fact, in Florida, it incorporates the SAFE Act into Chapter 494, which governs mortgage originators.
So they didn't change them any?
No.
Florida has no rules that are different than in Dodd-Frank, SAFE Act. Okay. If your state has no exemption under the SAFE Act, you will have to use a licensed mortgage loan originator on every deal. In theory, if you are married and you both have IRAs, then that's 4 plus 4 plus 3 plus 3 equals 14 deals a year in various entities. That's a lot of leeway without having to get licensed. Remember, too, this is only a summary, blah, 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 disclaimer, disclaimer, disclaimer. Okay. On the fixed rate, I think we've covered that, actually. Since the new law apparently says the rate needs to be fixed for 5 years, a rate which is fixed to an index is a fixed rate. But, this is a good point. It is the index fluctuation that is variable. So unless the law more specifically defines what is a fixed rate, I'm thinking that my fixed rate will be something like prime plus 12% with lots of discounts for early rent payments. I don't know about that. But the point that he's making here is that if your rate is tied to LIBOR, your rate can change without it being considered an adjustable rate mortgage. It's the LIBOR rate that is fixed.